whole lot better than where he is today. Like they can maybe prevent something from being worse, but they can't necessarily, stop it. And like the woman in this video said, maybe he's too far gone into the disease now because he was never diagnosed and now he can't even take the medication. So it breaks my heart.
I would have given him the medical attention he needed. He'd be walking today.
What do you think Paul's case should tell Tennesseans about the death penalty here?
That they could execute an innocent man, and they shouldn't take that chance. I don't want anybody executed in my name, and when the state does that, that's what they're doing. They're executing somebody in our name. He has a really good attitude, and that makes it even better. Everybody says, why isn't he angry and all that? I said, he's so happy to be out, you know.
Paul, did you think that you were going to die in prison?
Probably. I thought that for a long time.
Do you think about what if this never happened?
Nope,
Why not?
because I'm better off not thinking about it.
Yeah,
You're
what's
probably
the
right.
point?
Oh well.
Oh well. That is his answer. Oh well, because he just lost 22 years of his life. Oh well. I mean, I don't think I'd be so, you know, I can't think of the word, but so easy breezy about it. I think I'd be a little upset. But look how he takes it in stride. And I mean, how else can you? When you're in a situation that you have no control over and nobody is listening to you or understands you or believes you, it's very disheartening. And you just start to lose faith in people and the system and just everything in life. And it's amazing that he still has a positive attitude. So, what is his story? Let's dive into that. So, I am on the innocenceproject.org webpage. This is the story of Paul House. So, Paul House served 22 years on Tennessee's D row before evidence of his innocence and the intervention of the U.S. Supreme Court cleared him of unaliving and led to his release. So, here is the crime. In the summer of 1985, Carol Muncie was found unalive near her home in rural Luttrell, Tennessee. She was dressed in a nightgown and a house coat. Her body was found under some brush on a bank of a creek. That was my dog, like getting off the couch. She's being all weird and like stretching out all about it. She's being all crazy. Sorry. Okay, so she was dressed in a nightgown and a house coat. Her body was found under some brush on a bank of a creek. She had been arred and beaten. And that's what we know. All right, so the arrest. A few months before Muncie's unaliving, Paul House had moved into his mother's nearby home. Almost immediately after the incident, police suspected that House, an outsider with a criminal record, was responsible for Muncie's end of her life. So, why would they, it's like almost like they wanted to pin it on someone who wasn't from this town. So, the conviction at trial. 2 witnesses for the state testified that they had seen House wiping his hands on the night of the crime near where Muncie had been found. A pair of jeans collected from House had BLOOD on them, and the forensic expert testified at trial that matched Muncie's ABO type, her BLOOD type. So a forensic expert also testified that House's BLOOD type matched the male fluid found on Muncie's underwear. So a forensic expert testified on the stand that it was a match, and this happens often in cases where they say things like it was a match or within a certain degree of scientific certainty, blah 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 blah. But that's not actually the standard, and you can't say that. You're not supposed to say that in court because it is very prejudicial to the to the jurors, and a lot of people, lay people, even I, don't understand how the DNA works. We know, oh, DNA match? Okay, that's the guy. But it's not that simple and it's not that easy. And there are chain of custody issues and there are bias law enforcement and there are, I mean, it's just the list goes on because there are multiple ways in which DNA evidence can be manipulated, altered, what have you. It might not be a match at all, and you might say, within blah 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 certainty, this is a match, and misleading the jurors altogether. So you have to take it for what it is, and realize that DNA just isn't the smoking gun that everybody thinks it is. It's not the nail in the coffin for the defendant. All right, so in February 1986, the jury convicted House of first-degree unaliving and sentencing him to the D row. So post-conviction, now that he's sitting in prison, you have all these appeals that you can do, but a lot of the times it doesn't really take you anywhere. So let's see what happens. Because he was there for 22 years. So while House's attorneys were appealing his conviction, several witnesses came forward with evidence that the victim's husband had ended her life, and claiming that he was potentially violent with her. So two women claimed that Mr. Muncie had confessed to the crime at a party one night. Oh, what a peach. He confesses to doing that. Anyways, all right, so a third woman saw him hitting his wife at a dance. A fourth said that he had asked her to provide an alibi for him on the night that his wife's life ended. Interesting. Very suspicious, but then why not look at him? Why didn't they go after him? And why did they go after House? So further analysis of the BLOOD on House's genes cast doubt on whether it was actually deposited during the course of the crime. And that's what I'm talking about. It doesn't always happen the way, it can be transferred easily by evidence techs who are taking the evidence in if they're not careful. So this included testimony from a former Tennessee state medical examiner who stated that in his view, the BLOOD on the genes showed enzyme decay, which he testified was consistent with the BLOOD that was taken at Mrs. Muncie's autopsy and transported in vials without preservative or refrigeration. Okay, so they're saying on his gene, the person who testified, it had the same enzyme, so it must have been hers, but that doesn't tell you definitively that it's a match. The decay would not be expected to be found in BLOOD that came in direct contact with House's pants while the victim was alive. That's a good point. All right, so additional evidence supported the theory that BLOOD collected at Muncie's autopsy had spilled on House's genes after they were collected as evidence, whether accidentally or deliberately. Could have been done by someone. All right, so the genes had this enzyme decay, which means that it was not fresh when it landed on the genes. And so now we think it could be accidental or deliberate that it landed on the genes in some part of the investigation. So the vials were not sealed. Well, that's important because you could easily have a spill then. And were driven 10 hours to the FBI lab by two law enforcement officers. The BLOOD spoiled during the trip due to heat exposure. I wonder what the temperatures were. And then FBI records showed that a significant amount of BLOOD from the autopsy vials were missing when the officers arrived at the lab. Okay, so FBI records showed that a significant amount of the fluid from the autopsy vials were missing, meaning it very easily could have spilled. And it's more probable than not that it was spillage on his jeans. So more exculpatory evidence came in the late 1990s after House had spent over a decade in prison. Advanced DNA testing revealed that the male fluid from Muncie's underwear and nightgown belonged to her husband and not House, contrary to the testimony of the FBI expert at trial, who had incorrectly told the jury that only House's BLOOD group antigens could have been the source of those male fluid stains. All right, so he was eventually released and exonerated. House's appeals, which called for his conviction to be overturned in light of the array of new evidence, was rejected by several courts before his case was heard by the U.S. Supreme Court in 2005. The Innocence Project filed a friend of the court brief on his behalf in the Supreme Court. On June 12, 2006, the court ruled that any reasonable juror would probably not have convicted House had they been aware of the new evidence in his favor, and sent his case back to the district court. So the Supreme Court sent it back to the district court to review everything all over again. Supreme Court says something's not right, look at it again. In Tennessee, U.S. District Court Judge Henry Matisse Jr. overturned House's conviction and ordered the state to either release House or to retry him within 180 days. The state appealed the decision but lost. Bail was set at $500,000, and then it was reduced to $100,000. An anonymous donor paid the 10% bond. Well, that was nice of them. And House, who suffers from chronic multiple sclerosis and is confined to a wheelchair, was released from the Lois M. DeBerry Special Needs Facility on July 2nd, 2008. He had served 22 years on D. Row. Could you imagine that? I mean, I cannot. That's why I'm doing this, because these people's stories need to be told, and I really hope you like this video, comment, help me get this video out, because these people are victims of the justice system just as much as the victims of the crimes, and they really need their stories told. That's why I do this. So if you help, you can help get this story out by liking the video, so I appreciate that. Thank you. All right, so prosecutors requested permission to conduct further DNA testing in the case while House was on bail. The results from testing conducted on a hair found at the crime scene, material from under the victim's fingernails, and other items pointed to at least one other unknown suspect. So they didn't. Did they even look into the husband and then this other possible suspect? Additional investigation conducted by House's new trial team, Assistant Public Defender Dale Potter of Tennessee and Linda Kenny Baden of New York, who agreed to assist House pro bono, cast further doubt on the state's evidence against House. In light of the DNA test results and other evidence, prosecutors dropped all of his charges against House on May 12th, 2009. So that is his conviction story. I have this coming from the Tennesseans. Oh, that's my dishwasher, sorry. All my appliances are musical. They sing songs to me. All right. Anyways, so Tennesseans for alternatives to the DP. So that's what this website is. I just wanted to go over it because it has an article about Paul Gregory House a case of wrongful conviction and exoneration. So in June of 2006, the United States Supreme Court ruled that in the case of Paul House, no reasonable juror viewing the record as a whole would lack reasonable doubt. In other words, no juror in America would find Paul House guilty of the 1985 unaliving of Carol Muncy. One would think that when the highest court in the land says a person is not guilty, that person would be released from D. Row. Sadly, in the case of Paul House, another 3 years would pass before House would be a free man. That is such BS. Like, why? As soon as government says, hey, you're not guilty, you should be out of there. Why was he in there for 3 more years? This is ridiculous. This ruling was not the first time that House had been forced to accept unfair treatment from the federal court system. In 2002, the United States Sixth Circuit Court of Appeals, in a 7-4 decision, ruled that House deserved to have new evidence of his innocence examined by Tennessee state courts. Nearly 2 years later, with 4 new appointments to the Sixth Circuit, the state of Tennessee responded to that it would respectfully decline to act on the court's mandate. House was convicted of the 1985 unaliving of Carolyn Muncy, a woman who lived near him in Union County. The state presented R as the motivation for the unaliving and as the aggravating factor that called for the sentence of taking House's life. While no witnesses were available, 2 pieces of physical evidence pointed supposedly to House. Was the biological materials. And as we know, both of those have been tested and they were proven to not be his. So the BLOOD and on his pants and the fluid, the male fluid on her nightgown. So in recent years, however, all of this evidence has been called into question. DNA testing has conclusively proven that Paul House did not R Carolyn Muncy. The fluid found on the body actually belonged to Muncy's husband, Hubert. This fact calls into question the state's entire theory of the crime and puts suspicion on Hubert Muncy. Since the time of the trial, 2 witnesses have come forward and testified that while drunk, Muncy admitted to them that he ended the life of his wife in a drunken argument. Muncy was widely known to be an alcoholic who routinely hit his wife. Another witness had come forward and testified that Muncy requested that she provide him with an alibi for the night of the unaliving, and 3 other witnesses have implicated Muncy. So, a lot of people pointing the finger at him. The BLOOD on Paul House's pants brings up even more questions. While it did come from Carolyn Muncy's body, the AP has reported that the pants may have been tampered with by officers. Interesting. 4 vials of BLOOD were taken from the body after she was unalived, but by the time the vials arrived for expert testing, only 2.5 could be counted for by anyone, and 1 empty vial showed evidence of leakage. The forensics experts have testified that the BLOOD was likely spattered from those vials and did not come from Muncy's body while she was alive. Remember the enzyme of deterioration, of decomposition, decay. Blood goes through that too because it's alive. So it has living cells in it, so it starts to decay, and you get that enzyme. All right, so in his time on D. Row, Paul House had been diagnosed with MS. He is now confined to a wheelchair and unable to bathe or shave himself, and has difficulty speaking. So sad. 22 years of his life the Tennessee took from him. In December 2007, federal judge Harry Matisse ruled that the state had 180 days to retry House or release him. The state appealed the ruling to the Sixth Circuit Court of Appeals, who quickly upheld the judge's ruling. The state determined to move to retry House on first-degree unaliving but not seek the DP. House remained in state custody until bail could be set. Such garbage. So you just had the Supreme Court say you're not guilty of this crime, but yet you're still sitting in prison because they want to appeal. The state wants to appeal. It doesn't make sense to me. So the state determined to move to retry. All right. So on July 2nd, 2008, after nearly 23 years on D row, Paul House was freed from prison with an anonymous donor paid. When an anonymous donor paid his bond, House moved into the house of his mother, Joyce, under house arrest while he awaited trial. More physical evidence in the state's possession since 1985, including a hair found in the victim's hand, as well as fingernail scrapings, were tested and not a DNA match to House. Finally, dog, can you stop kicking the cord? Sorry. It just has to be part of the show every time. All right, so finally, on May 12th, 2009, District Attorney Paul Phillips dropped all charges against House, making him the 132nd person freed from D row nationwide and only the second in Tennessee. So that is Paul's story. And here I want to read, this was an article that was soon after he was exonerated. Paul House and his elated mother celebrate exoneration with a trip to California. So Paul House may have lost over 2 decades of his life in prison as a result to his wrongful conviction, but he and his mother are looking towards the future. With Paul's grandfather's 90th birthday coming up, his mother couldn't think of a better way to celebrate than a trip to visit him in California, where he lives. In the 22 years that Paul House served in prison, he maintains his innocence, and he hoped new evidence would exonerate him. More than 2 decades after House was sentenced to D row, DNA testing and other evidence finally cleared his name yesterday. So it was the 12th. So this was the article that was just posted right after it just happened. So his name was cleared of R and unaliving of Carolyn Muncie. And as we know, the DNA was not his. House's case highlights the need for courts to look closely at appeals based on new evidence of innocence. Today's Los Angeles Times notes that the Supreme Court narrowly agreed to grant House a new federal hearing on the evidence of his innocence after other courts refused. Long after his conviction, however, DNA evidence proved that a male fluid stain on the victim's clothes had come from her husband and not House, but the Tennessee courts and the federal appeals court said that evidence did not prove he was not guilty. The judge, so that's ridiculous, but whatever. Okay, so I guess she could have gotten it from her husband and then still been unalived by someone else, totally, but it doesn't make, it doesn't make as much sense as the person who did that is also the unaliver. So anyways, where was it? So the judges said that there was still strong circumstantial evidence against House. One dissenter on the federal court, however, called the case, quote, an authentic whodunit where the wrong man may be executed, end quote. For 2 decades, the Supreme Court had put up procedural barriers against reconsidering old cases. But the justices took up House's appeal to consider for the first time whether new DNA evidence could require reopening an old case. In a 5-3 decision in House v. Bell, Justice Anthony M. Kennedy said that, quote, reliable new evidence calls for taking a new look at an old case if it casts real doubt on the defendant's guilt. If the court had split 4-4, the conviction would have been upheld. The three dissenters, led by Chief Justice John R. Roberts Jr., said House did not, quote, present such compelling evidence of innocence to require reopening his case. Did not present such compelling evidence. Okay. So that is the case of Paul House. Let me get his photo back up here. 23 years served. I think it's, some say 23, some say 22. So I'm assuming it was probably close to 23 years, just shy of 23 years. In Tennessee for first-degree unaliving, and he was convicted for it. He was sentenced to D-row, and yeah, as you can see, inadequate defense, unvalidated or improper forensic science would be the contributing causes of his first conviction. Potentially inadequate defenses, unvalidated or improper forensic science. And that is true because it happened in 1989 or 85, and back then we didn't have DNA like we do now. I mean, you preserved it. I think people were smart enough to know, like, hey, we're going to need this one day, but we don't know what to do with it yet. So people were just started reserving body fluids from others, and now we're trying to solve old cases. But in this case, I absolutely approve, because we should be finding the actual assailant and not
Bye.